For 20 years, I worked extra shifts and saved every spare dollar, dreaming of the day I would own my own piece of land. Not just any land, but a ranch with enough space to breathe freely, away from the cramped apartment buildings and nosy neighbors of city life. When I finally found 30 acres in Texas Hill Country with a modest farmhouse and barn, I knew immediately it was everything I had waited for. The realtor mentioned it was part of a rural homeowners association called Whispering Pines Ranch Estates, but assured me it was minimal involvement. Just basic rules to maintain property values, she said with a wave of her hand. Nothing intrusive. Most people here barely remember they are in an HOA. I did not think twice about it. After signing the mountain of paperwork, I stood on my porch watching the sunset paint the sky orange and purple over land that was finally mine. Within the first month, I converted one of the spare bedrooms into a secure room for my gun collection. 15 years of carefully acquiring firearms that represented American craftsmanship and history. Everything from my grandfather's Civil War-era Springfield rifle to modern sporting rifles, each one legally purchased and responsibly maintained. My most prized possession was a rare Winchester that my father had given me before he passed. Behind my barn, I constructed a proper shooting range with substantial safety berms as backstops and clear sight lines. I took pride in following every safety protocol, creating a space where I could practice a constitutional right that had been part of my family heritage for generations. The first community meeting fell on a Tuesday evening at the local community center. I attended more out of curiosity than obligation, wanting to meet my neighbors. The room was cramped with folding chairs arranged in neat rows. About 30 people milled about making small talk before a woman with perfectly coiffed silver hair called the meeting to order with a sharp rap of her gavel. "I am Karen Wilkins, HOA president," she announced, her voice carrying authority that seemed disproportionate to the casual rural setting. The meeting progressed through mundane matters, landscaping contracts, road maintenance, and seasonal decorations. During the open floor session, I introduced myself as a new resident and mentioned my shooting range. The temperature in the room seemed to drop instantly. Several heads turned sharply in my direction. Karen Wilkins locked eyes with me, her pleasant smile vanishing. "We do not allow that sort of thing here," she declared firmly, as if speaking for everyone. I explained my safety measures, the significant distance from other properties, and my perfect record as a responsible gun owner. "Plus," I added, "I believe Texas state law protects firearm ownership on private property regardless of HOA regulations." Karen's expression hardened. "When you purchased property in our community, you agreed to abide by our covenants," she said coldly. "The Second Amendment does not supersede our community standards." Several neighbors nodded in agreement while others looked uncomfortable, avoiding eye contact. A man in the back corner, older with a military bearing, caught my eye and gave me a subtle nod of support. As the meeting concluded, Karen approached me directly. "I would strongly suggest you review the community bylaws," she said without warmth, "especially regarding activities that might endanger others." I drove home that night with an uneasy feeling settling in my stomach. The dream property I had worked decades to afford suddenly felt less like freedom and more like contested territory. What should have been a simple enjoyment of constitutional rights now appeared to be setting the stage for conflict with people who believed their authority extended into the most fundamental rights of property ownership. I resolved to look more closely at those bylaws, though I remained confident that no HOA could legally restrict gun ownership on private property. 3 days after the meeting, an official letter arrived in my mailbox. The Whispering Pines Ranch Estates logo was stamped in aggressive red ink at the top of the page. The letter cited Bylaw 29.4, no weapons or dangerous items permitted on properties within community boundaries. It demanded I cease all firearms activity immediately. That evening, I pulled out the 100-page covenant document I had received at closing, but like most homebuyers had only skimmed. After an hour of searching, I located the rule buried deep within the text. The wording was vague at best. No activities or items that may present a danger to community residents shall be permitted on properties. Nothing specifically mentioned firearms. I called my friend Marco, a lawyer who specialized in property rights. After sending him the documents, we met for coffee the next morning. Marco shook his head as he reviewed the papers. "This is shaky legal ground at best," he explained, circling the vague bylaw with his pen. "Texas state law explicitly protects firearm ownership on private property, even within HOAs. Their interpretation is extremely stretched." Marco highlighted several court precedents where homeowners had successfully defended against similar HOA overreach. "The Constitution and state statutes trump HOA bylaws," he said confidently. "Their vague wording about dangerous items cannot be reasonably interpreted to ban legally owned firearms." Armed with highlighted legal statutes and court precedents, I requested to address the board at their next scheduled meeting. The community room felt smaller this second time, with Karen and 4 other board members perched at a table slightly elevated above the residents. About 20 neighbors attended, more than at the regular community meeting. "I have researched Texas Property Code Section 202.001, I began, holding up my documentation. "It clearly states that HOAs cannot prohibit lawful firearm ownership or use on privately owned property within the association." I had barely finished my opening statement when Karen interrupted. "The Second Amendment does not apply here," she declared, her voice cutting through the room. "When you purchased in our community, you agreed to abide by our rules. Community safety supersedes individual preferences." One of the board members, a thin man with wire-rimmed glasses named Gerald, spoke next. "We have families with children here. No one wants to hear gunshots or worry about stray bullets." "My range exceeds all safety recommendations," I countered. "The nearest property is over half a mile away, with substantial safety berms. There is zero danger to neighbors." Karen gestured to another board member who produced a folder. "We have prepared a clarification to Bylaw 29.4, she announced, "to remove any ambiguity." The vote happened so quickly it seemed choreographed, each member raising their hand in perfect succession. Unanimous decision to clarify the existing bylaw, explicitly banning all firearms and shooting activities on any property within Whispering Pines Ranch estates. "This is clearly targeted at me," I stated, my voice steady despite my rising anger, "and it violates state law." Karen smiled thinly. "You are welcome to pursue legal remedies if you disagree. Until then, the clarified bylaw stands effective immediately." As residents filed out, some avoiding my gaze while others gave sympathetic glances, I remained seated. I watched Karen organize her papers with practiced efficiency, her satisfied smile barely concealed. "I will be pursuing those legal remedies," I said quietly when most had left. Karen looked up, her expression cold. "This board does what is necessary to protect our community. I suggest compliance would be easier for everyone involved." I stood and gathered my useless legal documents. This fight had only just begun, and it was clear the HOA board had no intention of respecting either state law or constitutional rights when they conflicted with their vision of control. 1 week later, a certified letter arrived requiring my signature. I signed for it with growing apprehension, then read its contents with disbelief. Surrender all firearms to HOA management for verification and removal from property within 14 days. Noncompliance will result in fines of $200 daily. My hands shook with indignation as I read the letter twice to ensure I understood correctly. This felt like something from a dystopian novel, not rural America in Texas of all places. The HOA had crossed from overreach into outright delusion if they believed they had authority to confiscate legally owned property. That afternoon, I contacted the Texas State Rifle Association. The representative sounded genuinely shocked when I explained the situation. "Document everything," she advised. "This is one of the most egregious HOA overreaches I have encountered. We have attorneys who specialize in these cases." By the next day, I had been connected with Sarah Reynolds, a gun rights attorney who requested copies of all correspondence and documentation. "They have absolutely no legal standing," she confirmed after reviewing everything. "But that does not mean they cannot make your life difficult while we fight this." My property soon became a surveillance target. Karen's black SUV crawled past multiple times daily, camera pointed toward my land. Sometimes she would park at the road entrance and simply watch my house for 30 minutes before driving away. I installed additional security cameras covering all angles of my property, documenting each drive-by. Some neighbors began to avoid eye contact at the community mailboxes. Others, however, offered quiet support. Mrs. Colton, an elderly widow from 2 properties over, approached me one evening as I collected my mail. "They tried to force the Hendersons to remove their American flag last year," she whispered, glancing around nervously. "Said it was too large and violated decoration standards. The Hendersons moved rather than fight. Karen always finds a way to win." "Not this time," I assured her. 3 days later, I found an anonymous note tucked into my mailbox. "We are watching. Any gunshots reported immediately. Sell and leave if you know what is good for you." I added the note to my growing file of documentation. The following day, the local sheriff arrived at my property, looking uncomfortable in his official capacity. "Got some complaints about gunfire," he explained, though his expression suggested he found the task distasteful. "Just doing a check since we received multiple reports." "I have not fired a single shot since receiving the HOA warning," I told him truthfully, showing him my newly installed security cameras. "Those cameras would have recorded any shooting activity. Feel free to review the footage." The sheriff nodded slowly. "Between us," he said, lowering his voice, "you are breaking no laws here, but these HOA disputes can get nasty. Just wanted to give you a heads up that they are pushing hard on this." After he left, I reviewed my security footage from the previous days. Sure enough, there had been no gunfire, meaning someone had filed false reports against me. The confrontation came to a head on day 12 of my 14-day ultimatum, when my perimeter alert system notified me of movement along my property line. I watched the live feed on my phone as Karen and 2 board members walked the boundary of my land with clipboards and cameras, periodically stopping to take notes and photographs. I grabbed my phone to record and walked out to meet them. "You are trespassing," I called out firmly from my porch before approaching. "This is private property." Karen turned, seemingly unsurprised to see me. Her smile never reached her eyes. "As HOA officials, we have inspection rights," she responded smoothly. "We are documenting continued violations." "What violations?" I demanded, keeping my phone recording. "I have not fired any weapons since your notice." "We have reports that suggest otherwise," said Gerald, the thin board member, without looking up from his clipboard. "Multiple neighbors have complained about gunfire." "That is categorically false," I stated. "My security cameras record 24/7. There has been no shooting here. Those reports are fabricated." Karen's expression hardened. "The inspection clause in our bylaws gives us the right to verify compliance with community standards. Your shooting range remains intact, which signals intent to violate our rules." "The range violates no laws, and you have no right to enter my property without permission," I countered. "Please leave now." The three exchanged glances before Karen nodded curtly. "Your time here is limited unless you comply," she said as they turned toward their vehicles parked on the road. "The fines begin in 2 days. They will accumulate until compliance or foreclosure." I stood at my property line watching them leave, a chill running through me despite the warm Texas afternoon. This had escalated beyond a simple dispute about rights. Their determination to exert control had become personal, and their willingness to fabricate violations suggested they would stop at nothing to force my compliance or removal. That Thursday, I left early for my job at the engineering firm, with a crucial client presentation scheduled for mid-afternoon. Throughout the meeting, my phone kept vibrating. Security alerts from my home system flashed repeatedly, but I could not check them during the presentation. By the time I finished, there were 17 notifications. I pulled up the security feed with trembling fingers in the parking lot. The footage showed a locksmith working on my front door, while Karen Wilkins stood behind him with Gerald and another board member. The timestamp showed 2:14 p.m. I watched in horror as they entered my home without permission or warning. Speeding home, I called the sheriff's department, explaining the break-in that was occurring. The dispatcher promised to send deputies but warned it might take time given their rural location. My hands gripped the steering wheel so tightly my knuckles turned white as I pushed my truck to its limits. The front door swung open too easily under my touch when I arrived home, no resistance from the deadbolt that should have been engaged. Afternoon sunlight streamed through my living room windows, illuminating dust particles dancing in the air. Something felt wrong beyond the obvious break-in. My heart pounded as I rushed to my office where the gun safe dominated the corner. The heavy door hung open, the interior shelves completely bare. My grandfather's Civil War-era Springfield rifle, my father's Winchester, my entire collection built over 15 years, all gone. Even my documents and ammunition had been removed. A typed note on HOA letterhead sat on my kitchen counter. Items removed pursuant to Bylaw 29.4, revised. Property stored at Community Management Office pending resolution or permanent removal. They had provided an itemized list of everything taken, as if that somehow legitimized their theft. I called the sheriff again, my voice shaking with rage and disbelief. When 2 deputies arrived 40 minutes later, I showed them the security footage of the entire illegal entry. The first deputy, a younger officer, appeared genuinely shocked. The senior deputy maintained a professional poker face as he documented everything. "They claim HOA authority for the entry and seizure," the senior deputy explained as he took my statement. "We will need to investigate the legality of that claim." "There is no legal authority for an HOA to enter a home without permission or court order," I insisted. "This is breaking and entering burglary." After reviewing more of the security footage, the senior deputy pulled me aside while his partner continued taking photographs. "This is not right," he said quietly. "Regardless of HOA claims, this is not legal entry. Keep this footage secure. You will need it." Their official report, however, remained frustratingly noncommittal. They classified it as a civil dispute rather than a criminal break-in, promising to forward the information to investigators but offering little immediate action against Karen and her accomplices. After the deputies left, I sat in my empty office staring at the open safe. The collection represented not just significant financial value, but irreplaceable family history and personal meaning. The thought of Karen's hands on my grandfather's rifle made me physically ill. That night, a knock at my door startled me. I approached cautiously, checking the security camera first. 3 neighbors I barely knew stood on my porch. An elderly man I recognized from the initial community meeting, a middle-aged woman, and a younger couple. I opened the door reluctantly. "We saw what happened," said the elderly man, introducing himself as Frank Davis, a Vietnam veteran. "Several of us have security cameras that captured their vehicles at your property today. We have the footage if you need additional evidence." The middle-aged woman, Catherine, spoke next. "We have had enough of this tyranny," she said firmly. "They have gone too far this time." The younger couple nodded in agreement. "We moved here for privacy and freedom," the husband explained, "not to have self-appointed dictators rifling through our homes." Their support provided a small measure of comfort in an otherwise devastating day. We exchanged phone numbers, and they promised to provide their security footage showing the entire operation from different angles. After they left, I called Sarah Reynolds, the gun rights attorney, and explained what had happened. Her sharp intake of breath conveyed her shock better than words. "This crosses every legal line," she said after a moment. "Breaking and entering, theft, constitutional violations. We need to file for an emergency injunction immediately to prevent them from disposing of your property." I agreed, choosing to fight through proper legal channels rather than direct confrontation, though the violation of my home made that decision difficult. That night, alone in my house that no longer felt secure, I realized this fight had become about far more than gun rights. It was about the fundamental security of one's home against unlawful invasion, and the limits of authority that small groups of people could claim over their neighbors. The gun rights attorney's office walls displayed framed constitutional amendments alongside legal credentials and awards. Sarah Reynolds listened intently as I provided a complete timeline of events, security footage, and all correspondence from the HOA. "What they did constitutes breaking and entering, theft, and civil rights violations," she explained, tapping her pen against my documented timeline spread across her desk. "The HOA has no legal authority to enter your home or seize lawfully owned property, regardless of what their bylaws state." Sarah outlined our immediate strategy: file for an emergency injunction to prevent the HOA from disposing of my property, followed by a civil lawsuit for damages and constitutional violations. She warned me about the costs. The emergency injunction filing alone would cost nearly a month's salary, but the alternative, losing irreplaceable family heirlooms, was unthinkable. "There is another option," she added carefully. "You could also pursue criminal charges against the individuals involved. Breaking and entering is a felony, regardless of whether they claim HOA authority." I considered this, but decided to focus first on recovering my property. "Let us start with the emergency injunction and civil case. I can always pursue criminal charges later if necessary." Through the legal discovery process that followed, we uncovered Karen's hidden motivation. Her teenage son had suffered an accidental shooting injury at a friend's house 15 years ago. Though he had recovered completely, the incident had turned her vehemently against private gun ownership. Her crusade was personal, not policy-driven. The HOA's lawyer, a sharp-suited man named Philip Andrews, attempted to intimidate us with countersuit threats. "My clients will pursue damages for defamation and legal costs if you continue with this frivolous action," he wrote in a curt email. Additionally, daily fines for noncompliance continue to accumulate and now exceed $3,000. 3 days after filing, we stood before Judge Michaels for the emergency injunction hearing. The courtroom felt impossibly formal, the wooden benches hard and unforgiving as we waited for proceedings to begin. Judge Michaels, an older man with a reputation for strict constructionist views of property rights, reviewed our filing with an expression that revealed nothing of his thoughts. The court finds sufficient cause to issue a temporary restraining order preventing disposition of the plaintiff's property pending full hearing, he finally declared. The items must remain untouched and secured at the HOA office until this case is resolved. Outside the courthouse, local news cameras had gathered. The story of an HOA breaking into a home to seize legally owned firearms had attracted media attention beyond our rural community. Karen played to the cameras expertly. "We are protecting our community from potential tragedy," she declared dramatically. "Sometimes difficult actions are necessary for the greater good." When reporters approached me, Sarah advised a simple statement. "This case is about illegal entry into a private home and theft of legally owned property. We are confident the court will uphold both property rights and constitutional protections." That evening, Karen called an emergency community meeting, clearly timed to capitalize on the media attention. The community center was packed beyond capacity, with residents standing along the walls. My supporters had managed to secure me a seat near the front where Karen could not ignore my presence. Karen painted me as a threat to neighborhood children, her voice trembling with manufactured concern. She spoke of her son's injury without mentioning that it had occurred at someone else's home under completely different circumstances. "Do we want to wait for tragedy to strike our community before taking action?" she asked the crowd. When given my allotted 2 minutes to speak, I remained composed despite my simmering anger. I addressed only the legal facts, explaining the laws protecting both firearm ownership and private property against unauthorized entry. "This case is not about guns," I concluded. "It is about whether we want to live in a community where self-appointed authorities can enter our homes without permission and take our property without due process." Several neighbors nodded in support. Frank Davis, the Vietnam veteran, stood despite his difficulty walking. "I served this country to protect the very rights being violated here," he stated firmly. "If they can take his guns today, they can take anything from any of us tomorrow." The tide of opinion seemed to shift as more residents considered the precedent being set. Even those uncomfortable with firearms appeared disturbed by the idea of HOA members entering homes and removing property. As the meeting concluded, Catherine, one of my newfound allies, passed me a note. "Emergency meeting tomorrow at Frank's house, 8 p.m. More supporters than you know." For the first time since the seizure, I felt a genuine spark of hope that justice might prevail against Karen's crusade. The community center overflowed with residents 1 week later when the HOA board called a special meeting to address what they termed community security concerns. Extra folding chairs were hastily arranged in rows too narrow for comfort. The atmosphere crackled with tension as Karen introduced her guest speaker, a national anti-gun activist with rehearsed talking points about community safety and statistics carefully selected to support their position. My attorney Sarah sat beside me, her calm presence steadying my nerves as whispers and sideways glances swept through the crowd. We had agreed she would speak for me at this meeting to ensure everything stayed on legal grounds. The activist concluded her emotional presentation with a dramatic gesture toward me. "This is the face of the threat in your community," she declared. Several gasps and murmurs rippled through the audience, but I also noticed many frowns of disapproval at her tactics. When finally permitted to speak, Sarah methodically outlined the illegal entry, the constitutional violations, and the unauthorized seizure of legally owned property. She projected photographs of my broken door lock and empty gun safe onto the community center wall. "The actions taken by this board expose every homeowner to potential liability for legal damages," she explained calmly. "And more importantly, they establish a precedent that your homes and possessions are subject to entry and seizure whenever the board decides it is justified." Frank Davis stood slowly, leaning on his cane. "I served this country to protect the very rights being trampled here," he stated firmly. "This is not about guns anymore. It is about whether we have any real property rights at all." The meeting took an unexpected turn when Catherine stepped forward with a folder. "I have obtained copies of board spending records through proper channels," she announced. "The board has already spent over $40,000 in HOA reserve funds on legal consultation regarding this matter, without required membership vote." She distributed copies of financial documents showing the unauthorized expenditures. The room erupted into chaos as homeowners realized their funds had been spent without proper approval. That money was supposed to be for road repairs and community landscaping. One man shouted from the back. Karen repeatedly struck her gavel, desperately trying to maintain control of the meeting. Her face flushed crimson as she demanded order. These expenditures were necessary emergency measures to protect community safety, she insisted. Gerald, the thin board member who had participated in the seizure, abruptly stood and moved toward the exit. "I cannot continue to support these actions," he announced loudly enough for everyone to hear. "I resign from this board effective immediately." His departure triggered further chaos. Another board member, a quiet woman who had rarely spoken at meetings, also stood to leave. "I was not informed about the home entry until after it happened," she stated. "I cannot be party to this." By meeting's end, a formal motion for board recall had been proposed, requiring signatures from at least 30% of homeowners to trigger a special election. Neighbors who had never spoken to each other now exchanged phone numbers and formed alliances in the community center parking lot. The community stood fractured, with battle lines drawn not over guns but over fundamental questions of governance and rights. Most surprising was the coalition forming in my support, people who had no particular interest in firearms, but who were deeply disturbed by the precedent of HOA members entering homes and seizing property. As we left the meeting, Sarah squeezed my arm encouragingly. "This is shifting in our favor," she said quietly. "Keep documenting everything. The court hearing is in 2 weeks." Karen watched us from the doorway, her usual confidence visibly shaken by the community's reaction. For the first time, I saw uncertainty in her expression. The wall of authority she had built was beginning to crumble as homeowners realized the true implications of allowing such power to go unchecked. That night, the petition for board recall collected signatures from over 40% of homeowners, well above the required threshold to trigger a special election. The balance of power was shifting, though the most important battle still lay ahead in court. The courthouse steps teemed with neighbors and local news crews on hearing day. What had begun as a personal fight had grown into a referendum on HOA power and property rights that attracted attention throughout the state. Inside, the judge's chambers felt solemn as he reviewed final arguments. This court finds the actions of Whispering Pines HOA constituted illegal entry, unlawful seizure of property, and violation of state-protected constitutional rights, Judge Michaels declared, his voice echoing in the hushed courtroom. All property must be returned within 24 hours, and damages of $75,000 awarded to the plaintiff. Karen sat rigid in her chair, face pale as the judge continued. Additionally, board members who authorize this action may face personal liability, as such violations fall outside protected HOA functions. HOA insurance typically does not cover intentional illegal acts by board members. The courtroom erupted in murmurs as the implications sank in. Karen and the remaining board members could be personally responsible for both the damages and legal costs, potentially facing financial ruin from their overreach. Outside, reporters thrust microphones toward me, but I kept my comments dignified. This ruling affirms that constitutional rights and property protections apply to everyone, regardless of community rules, I stated simply. No American should fear having their home invaded and property seized without due process. The emergency HOA election held the following week drew record attendance. The community center overflowed with homeowners eager to vote in new leadership. Neighbors who had previously avoided eye contact now approached me to shake my hand or offer support. "We moved here for freedom, not tyranny," became the rallying cry of the new board candidates. The slate of reform candidates included Frank Davis, Catherine, and 3 other homeowners committed to limiting HOA power to its proper scope. When votes were tallied, Karen and her remaining loyal board members were removed by overwhelming margins. The new board's first official act was to pass a resolution affirming that the HOA would respect all state and federal rights of homeowners, and establishing clear limitations on inspection powers. 24 hours after the court ruling, as ordered, my gun collection returned home. 2 HOA staff members delivered everything under the watchful eye of a sheriff's deputy. My grandfather's Springfield rifle bore a new scratch across its historic stock from careless handling, but otherwise the collection was intact. The following month, at neighbors' request, I hosted a firearms safety education day on my property. Even those who had no interest in owning guns themselves attended to learn about proper storage, handling, and safety protocols. "I still do not want guns in my home," Mrs. Colton told me as she watched a safety demonstration. "But I respect your right to have them in yours. That is what community should mean, respect for differences, not forcing everyone to live the same way." Karen Wilkins put her house on the market the week after the election. I saw her only once more, supervising movers as they loaded her furniture into a truck. Our eyes met briefly across the distance of her front yard. She turned away first. The new HOA board, with Frank Davis as president, focused on actual community needs, road repairs, common area maintenance, and a small playground for families with children. Monthly meetings became cordial affairs centered on practical matters rather than control and conformity. 6 months after the court ruling, on a clear Texas evening, I stood on my porch watching the sunset paint the sky in brilliant orange and purple hues. The shooting range behind my barn had been used that day for a community event, teaching responsible ownership and respect for firearms as tools requiring proper care and knowledge. Under the wide Texas sky, standing on my own land with rights restored, I realized the fight had never really been about guns. It had been about standing firm against those who abuse authority and the importance of neighbors uniting against overreach. "Your grandfather would be proud," Frank said, joining me on the porch with a cup of coffee. "Not just because you got his rifle back, but because you fought for something bigger than yourself." I nodded, watching nightfall settle over the 30 acres I had worked so hard to obtain. The dream that had almost been shattered was now stronger than before, built on a foundation not just of ownership, but of community and principles. In the end, Karen's attempt to control had united us in defense of something far more important than any single issue: the understanding that rights undefended become rights surrendered, and that true community comes from mutual respect, not enforced conformity.